Another smashing victory, and this one I think is going to be going to the United States Supreme Court, which could become the fourth Second Amendment gun case going there. What are we talking about? We're talking about the Fifth Circuit Court of Appeals. We're talking frames receivers. We're talking Vanderstock v. Garland. We're talking our good friends at the Firearms Policy Coalition. Guys, let's get into it. Okay, so here's the roadmap of what we're going to do. I'm going to be doing a quick shout out for a sponsor, and then I'm going to be giving you a super compressed summary of what happened and where we stand. For those of you who want that short but sweet, or maybe you're just helped by having that 10,000 foot view before we dive into some of the details and context, I hope that all helps. Then finally, for the folks who want it, I'll be going into more background and details. Everyone good with that? I hope so, because that's what we're going to do. So first, that quick shout out to today's sponsor, Collectors Firearms. For those of you who don't know, I was not raised in a household with firearms. My dad passed when I was young. I was raised by a single working mom, and she was by no means anti-firearms, but it just frankly wasn't something we talked about. I came to firearms by way of collecting military surplus, moving into the IPSC IDPA world, and well, the sickness just kind of kept progressing from there. That's what I find so interesting about Collectors Firearms, is because this was my gateway drug into the Second Amendment world. Collectors Firearms regularly has over 12,000 guns and 500 swords in stock. So sword boys, they got you covered. They deal in all sorts of different firearms, both new and used, as well as modern guns, all the way to antique guns, and they have firearms from every price point, starting from about $100 to over $500,000. You can browse thousands of modern and antique firearms to find your next firearm or memorabilia for your collection. They have expert staff on call 7 days a week to answer any questions that you may have. You name it, they say they've got it. And based on my perusal of their website, I can tell you they've got quite a bit. Whether you're a competitive shooter, plinker, or collector, Collectors Firearms has the right products for you. They say that they are the best damn gun shop in the world. Be sure to check them out. I've got a link in the description box to their Facebook page, thanks to YouTube rules, but if you Google them online, I think you can find that. So thanks to them, let's get to the compressed version of what we're talking about here. So the ATF announced a new rule in 2022 that completely changes the game on legally answering the question, what is a firearm? The ATF contends that the statutory definition passed by Congress as part of the Gun Control Act in 1968 was simply out of date and no longer that serviceable, and therefore it needed to be cleaned up in the name of good public policy. Anytime you hear someone say that, that translates to gun control, among other things. Now, our good friends at the Firearms Policy Coalition, be sure to check them out, link in the description box below, filed a lawsuit in the Northern District Court of Texas seeking to vacate the final rule on a variety of different grounds, most notably as a violation of the Administrative Procedures Act. The essential claim, among others, was that while the government agencies are allowed to interpret laws passed by Congress, they may not exceed what is written by Congress, as the ATF has allegedly done here. Long short for the compressed version, the FPC won in the federal district court, that's the federal trial court, and the rule was vacated. In other words, taken out. This was then later upheld by the Fifth Circuit Court of Appeals, District Court, Circuit Court. But the Supreme Court stepped in and basically reinstated the rule pending the outcome of the case. Again, that's the low resolution compressed version. We've covered all those steps as they have unfolded in greater detail. Be sure to check out our channel for those videos. So we're now back in the Fifth Circuit Court of Appeals, who once more smacked down the rule. However, thanks to the Supreme Court, the rule still stands pending any final action taken by the Supreme Court. So while the FPC is, for those of you not paying attention, winning every battle basically, the outcome of the legal war on this question still remains in doubt. But let's talk about this battle. How did we get here, and where are we going in somewhat higher resolution? So first you need to know that the ATF is going to be in for a beating when the first paragraph of the case opens like this. Quote, "It has long been said, correctly that the law is the expression of legislative will. As such, the best evidence of the legislature's intent is the carefully chosen words placed purposefully into the text of a statute by our duly elected representatives. Critically then, lawmaking power, the ability to transform policy into real-world obligations, lies solely with the legislative branch, where an executive agency engages in what is, for all intents and purposes, lawmaking. The legislature is deprived of its primary function under our Constitution, and our citizens are robbed of their right to fair representation in government. This is especially true when the executive rule turned law criminalizes conduct without the say of the people who are subject to its penalties. The agency rule at issue here flouts clear statutory text and exceeds the legislatively imposed limits on agency authority in the name of public policy. End quote. To get our arms around this, and I promise you this won't be painful, let's hit the highlights to create some context. So, 1968, the Gun Control Act is passed by Congress. This regulates firearms in interstate commerce. Under the GCA, the Gun Control Act, Congress granted to the Attorney General the power to prescribe rules and regulations necessary to carry out Gun Control Act's provisions. That's code for we've got this agency, and the agencies now are delegated in order to basically go out and do things, okay? So they can make interpretations and so forth. We're not to the ATF yet. That comes a little later. The Act defines the term firearm 4 different ways. You can find those down in the description box below. Then in 1978, the now recently created ATF promulgated a rule interpreting the phrase frame or receiver. Since then, the ATF has pretty much largely colored within those lines. However, in April of 2022, the ATF published a final rule changing, among other things, the 1968 definition of frame or receiver. Now, you can find a link to this in the Federal Register in the description box below. The rule took effect on August 24th of 2022, and the ATF split the phrase into 2 parts, assigning the term frame to handguns and the term receiver to any firearm other than a handgun, such as rifles and shotguns. ATF then defined the terms frame and receiver along the lines of what the 1978 rule, though with updated, more precise technical terminology, had. But, and this is where they really get into trouble, the ATF did not stop there. Really quickly, if you made it this far in this video, be sure to tell me in the algorithm that, hey, you support the Second Amendment by hitting the like button. Also, be sure to post up the comments, join the discussion in the comment box below. I'll be sure to check that out and be looking forward to weighing in. And don't forget to hang around to the end where we have a bit of a different quote of the day today. So be sure to hang around and check that out. Rather than merely updating the terminology, the ATF decided to regulate partial frames and receivers. Partial, so not yet a frame or receiver, partial. Under the new final rule, quote, the terms frame and receiver shall include a partially complete disassembled or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may readily be completed, assembled or restored or otherwise converted to function as a frame or receiver. But the terms shall not include a forging, casting, printing, extrusion, unmachined body or similar article that has not yet reached a stage of manufacture where it clearly identifiable as an unfinished component, part of a weapon, such as an unformed block of metal, liquid polymer, or other raw material. Okay, so basically, unformed raw material, that's not a gun. But somewhere between a pile of ooze, whether that's aluminum ooze, some other metal ooze, or polymer ooze, and a complete functioning firearm, it turns into a firearm. And this is going to be incredibly important because you see, the earlier on in the process that it becomes a gun, the earlier that you and your friends can all go to prison for violation of potential Gun Control Act issues. So you can see why it's important to play along here. When I say play along, I mean watch this video, not necessarily something else, just so we're clear. When determining whether an object is a frame or receiver, the ATF director is not limited to looking only at the object. This is according to the rule. When issuing a classification, the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or possessed with the item or kit. So as a concurring opinion in our Vanderstock case wrote, which by the way is of course linked in the description box below, quote, "The final rule is limitless. It purports to regulate any piece of metal or plastic that has been machined beyond its primordial state for fear that it might one day be turned into a gun frame or a gun receiver, and it doesn't stop regulating the metal or plastic until it's melted back down to ooze. The Gun Control Act allows none of this," end quote. So hopefully you can get a sense as to why this is such a big deal. Because if we don't know what is a firearm, if anything can be labeled as a firearm reasonably, then we've got big issues here. You know, it used to be that in my home state of Wisconsin, that basically anything that was part of a firearm once under our old statutory definition basically was considered to be a firearm, meaning if you put a screw into a firearm and if you take it back out, that screw is now a firearm. Now, thankfully, we've done away with that definition, but you can absolutely see how insane this gets, because now if I take that screw into a school, even though it's just a screw, I'm technically committing a felony. Now, we've covered this rule in far more exquisite detail. I don't want to rob you all of your time going into that here because I've already done it once before. We'll be sure to link one of or two of those videos in the description box if you want tons more detail about it. What I just wanted to do is I wanted to make sure that we're all up to speed on where this is going because, guys, I think this is going to wind up going to the U.S. Supreme Court for a big reason, among other things, which also from the case at page 28, as the court observed, an agency cannot label conduct lawful one day and felonious the next, and yet that is exactly what the ATF accomplishes through its final rule. Think about that. A government agency basically reclassified a federal statute, an act of Congress, from going from something that day one you're completely legal to day two you're not. So we get it. It's an unlawful rule. So what do we do? The Fifth Circuit remanded it back down to the federal trial court to work out a different remedy. At present, the remedy is to kill the rule. That's what the district court did. They killed the whole rule. But what the Fifth Circuit basically said is, look, trial court, you're doing too much here. You're striking down the whole rule rather than the merely infringing two parts of the rule that is under discussion as part of this case. In essence, the Fifth Circuit is saying, don't throw out the baby with the bathwater. What two parts are we talking about? Number one, the ATS proposed definition of the frame or receiver, including incomplete frames and receivers. And two, the ATF's proposed definition of a firearm, including weapon part kits. That's the ooze discussion. So what parts of the rule are seemingly going to be left standing if we can kind of look down the road here a bit? Well, time will tell, but presumably the parts dealing with marking of privately made firearms, PMFs, as well as record keeping, among maybe a few other bits. And I'm not so sure what direction the courts will go in, but again, if we look at the parts that are struck down and we separate that from the remaining parts, that seems to make sense, though I'm by no means necessarily happy with it. If enough people want me to go into more details to kind of clean up about what are the other parts remain standing, let me know in the comment field below. I'd be happy to check it out. I think maybe with the Fifth Circuit, who, by the way, has easily the most pro 2A record of any of the 13 circuits of the United States Court of Appeals. The reason why I think they're doing this is I think they're trying to clean it up to withstand the eventual and maybe inevitable Supreme Court scrutiny. I'm not so happy about the whole rule not being struck down. At least that's the way it looks like it's going to go. But that's what I think is happening. Time will tell. What do you think is happening? Do you think that this is going to work out well for us in the end? Do you think we're going to have victory at the U.S. Supreme Court? Or do you think that, no, we shouldn't be playing small ball, go for the whole thing? Let me know in the comment field below. Our quote of the day comes from Justice Thurgood Marshall, not a Greek philosopher. I know, strange. Justice Thurgood Marshall once wisely wrote, quote, "History teaches that grave threats to liberty often come in times of urgency. When constitutional rights seem too extravagant to endure, when we allow fundamental freedoms to be sacrificed in the name of real or perceived exigency, we invariably come to regret it." Always a timely statement, unfortunately, from the good Justice Thurgood Marshall. So we appreciate your time today. I look forward to seeing you all and joining you in the discussion, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.